Thank you, Chairman and members. I was in the middle of apologizing to the country for the language I used, which I said is beneath my character. I'm sorry to all those I offended, but please know I had been pushed to the edge. The people who know me know that that is not my character. I recognize my Member of Parliament for Nakawa East, Senior Counsel. Congratulations, my own. Honorable members, the institution I head has the widest mandate under the Constitution. Article 52 refers. This Article 52 lists not fewer than 9 responsibilities or tasks of the Uganda Human Rights Commission. In addition to these, there are others which may arise under the state of emergency. Today, honorable members, I should be attending to these functions. I should be supervising investigations. I should be reading files. I should be writing decisions or rulings. I should be constituting panels for tribunal sessions. Today, Mr. Chairman, I should be in the field hosting barazas, talking to refugees, interacting with stakeholders. I should be hosting press conferences talking about the major human rights issues of the day. I should be convening commission meetings. But, Chairman, I have spent the past 5 months fielding questions and defending myself before every media house in Uganda. I have spent the past 5 months telling them that I am not in hiding, that there is no investigation on me, that I am not a thief. I have spent the past 5 months telling journalists that I'm not in exile, that I'm not on the run, and that we Ugandans no longer go to exile, but instead receive and host millions of refugees. I have spent the last 5 months being terrorized by the media, receiving calls from friends and relatives who comfort me, and from haters who tell me to go to hell. I spend all my time worrying about posts on X, on TikTok, and other social media platforms. Mr. Chairman, I now have to defend myself before committees of Parliament. So far, I have received at least three invitations to appear before 3 different committees of Parliament. All the invitations arrived in 2 days. One of them required me to appear the next day. Mr. Chairman, none of those invitations is about the current human rights issues. They are all about responding to false and petty accusations. This is really sad. In addition to the Commission's mandate under Article 52 of the Constitution, Section 4 of the Uganda Human Rights Commission says, I quote, "The chairperson shall be the head of the Commission, be responsible for the direction of the affairs and for administration of the Commission, and monitor and supervise the work of the Secretary." I quote. I have been taken away from these roles. My full-time job now is to defend myself against baseless, malicious, and defamatory accusations. Meanwhile, the work of at least 3 members of the Commission, that is half of the Commission, is to conspire against the chairperson and one of their colleagues, to orchestrate a smear campaign against her, to place defamatory stuff in the media, to lodge baseless complaints against her at every investigative agency on the land, to report her to the President, to the Ministry of Justice and Constitutional Affairs, to the Attorney General, to Parliament, and do anything and everything to destroy her. Their constitutional mandate is irrelevant to them. The meetings they clamor for are not for work. They are intended to avail them a forum to humiliate, to harass and taunt the chairperson. I ask, where is the value for money for the Ugandan taxpayer. Honorable members, you live in this country. You have watched and listened for yourselves to the psychological terror I, Commissioner Kaheru, and a staff member suffer every day. Yesterday, you hosted here members of the commission. You listened to each one of them. You heard and witnessed the disrespect, contempt, hatred, and vitriol they harbor for me, their leader. You saw their demeanor. You heard their pettiness. I invite you just for a second to try to imagine what our meetings look like. Honorable Chairman and members, I was a member of the Uganda Human Rights Commission for 17 years. I actually was part of the Pioneer Commission. I worked under two different chairpersons, Mrs. Sekaja, the Pioneer chairperson, and the late Hadimedi Kagwa. I could never have imagined that a head of institution could be bullied, humiliated, harassed and taunted and disrespected, more so to that extent. I worked under Justice Irene Mulyagonja, then Inspector General of Government, for 8 years. I cannot fathom that we, her deputies, could ever have done to her anything near to what is being done to me. I have been a single mother to my son since he was 3 weeks old. Soon he will be 30 years old. He has a toddler son and a wife, and I'm their sole breadwinner. By the time a woman in my situation picks a pen, places it on paper, and writes a letter resigning her job.
Chairman, maybe we can have a procedure.
Chairman, we have some procedural issues.
Let the chairperson finish making her submission before we chip in.
She must be in unimaginable agony. On behalf of the Uganda Human Rights Commission, as currently constituted, I apologize to His Excellency the President, to this Parliament, and to all the people of Uganda and all stakeholders. We have let you down. Mr. Chairman, allow me now to respond to just a few of the accusations leveled against me. But there are so many. I'll just restrict myself to a few. On the alleged exclusion of some commissioners from activities, this is not true. One of the activities which brings together the chairperson and the members of the commission is the tribunal sessions. We have two panels which I constituted for all the 6 commissioners. All the 3 commissioners, Commissioners Stephen Basaliza, Simeon Subuga, and Jacqueline Atuhaire Rabukurukru, occasionally pick allowances for these activities, the tribunal sessions, and do not show up. We fail to realize a quorum, which may lead to our decisions being challenged in a higher court. Previously, single commissioners used to preside over sessions until we got legal guidance from the learned Attorney General. On at least 2 occasions, Honorable Jacqueline Atuhaire cancelled sessions even after picking all allowances for her driver and bodyguard. I initiate draft decisions and rulings and send soft copies to every commissioner. These 3 commissioners have never contributed any comment on any draft decision or ruling, but at least they sign the final copies. So it's therefore not true that they are excluded from activities. A lot has been said about a generator. Chairman, I have a generator allocated to me by virtue of my office as a power backup. I am the one who chairs all tribunal sessions and initiates the drafting of all our decisions and rulings. It was found necessary to give me power backup. I need power and Wi-Fi to do research and write those decisions and rulings. On the issue you began with, Mr. Chairman, closure of files and dismissal of cases, I have had a sustained and choreographed mantra of she has closed files, she dismisses cases. Let me begin by saying that the mandate of the Commission is a broad one. Complaints handling and specifically tribunal decisions are a tiny component of our mandate. Hearing cases, Mr. Chairman, is not part of the functions of the Uganda Human Rights Commission. It is a role derived from the powers of the Constitution under Article 53, Clause 2B of the Constitution. If I can read part of it loud. In the performance of its functions, the Commission shall have the powers of a court. In particular, Clause 2, the Commission may, if satisfied that there has been an infringement of a human right of freedom, order payment of compensation. So, these tribunal sessions are not a function as such, but are a fulfillment of the power given to us under Article 53 of the Constitution. I submit that even if there were no tribunal sessions, the Commission would continue to work. In fact, for your information, Mr. Chairman, the Uganda Human Rights Commission and the National Human Rights Institution of Canada are the only two national human rights institutions in the world with the power to convene, to sit as a court. So this is merely in fulfillment of that power. Back to the closure of files without a full hearing. Mr. Chairman, contrary to what you've heard, the decision to close cases which do not meet the required evidential threshold or on any other criteria was taken by the Commission sitting as a tribunal. I don't know whether members, these commissioners just forgot that we decided this as a tribunal. I don't know. By the way, Mr. Chairman, even courts of judicature dismiss some cases. Dismissal of cases is not unique to the Uganda Human Rights Commission. Apart from cases which don't meet the evidential value, other criteria for dismissal of cases include, there are many, but I'll just mention a few in the interest of time. Limitation of time. Some cases are filed out of time. Section 24 of the Uganda Human Rights Commission Act, Mr. Chairman, says no complaint shall be brought before the Commission after the expiration of 5 years from the date on which the alleged violation of a human right to which the complaint relates occurred. So, where we upon perusal of files, if I discover that this matter was filed out of time, this is a resource-starved commission. Why should I take it to a full hearing? Why don't I simply minute on it? This matter was filed out of time, and I instruct the director to communicate closure. I don't see why that should be a crisis. The other criteria, Mr. Chairman, is non-disclosure of a cause of action. For example, where the case is that of negligence, but has been brought as a human rights violation. We've received cases to do with accidents on the roads, where a driver accidentally maybe knocks someone, and either they are injured or they die. Such cases sometimes are brought to us as cases of violation of human rights. And these are cases of negligence. So once that is made clear at the time of preparation for the hearing, this case should not go to a hearing. It should be closed and the parties informed. There are cases which are closed on grounds of suing the wrong party. Let me give just one example here, but there are so many. There are cases of so-called mob justice, where an angry mob violently attacks and harms or even kills a victim, or in event where the police tries to rescue that victim, the victim dies in the police custody. Some of those cases are filed against the police, the same police which tried to rescue the victim. So where the evidence clearly shows that the victim was killed by the mob, but the Attorney General has been sued, why should this case go to a full hearing, Mr. Chairman? There are cases which are simply frivolous, embarrassing, and vexatious. Most of the cases I'm alleged to dismiss prematurely, Mr. Chairman, are brought by hardcore criminals, some of whom are murderers, defilers, robbers, rapists, etc. Let me give just one example, else we would spend here the whole day. Imagine a man who defiles his 6-year-old niece, pleads guilty in court and gets a 10-year prison sentence, filing a case against the police, saying he was detained for over 48 hours before being taken to court, and therefore his right to personal liberty was violated. These cases are commonest in our regional office in Arua, where men defile their brothers, little girls, their sisters, babies. So, how can, Mr. Chairman, how can any serious human rights body entertain such a case? What message would we be sending to victims of crime? What message would we be sending to institutions in the criminal justice system? I leave those questions to the committee, Mr. Chairman. The other reason some cases are closed without going through a full hearing are those cases which clearly are intended to divert the course of justice. Mr. Chairman, there are people who file complaints at the Uganda Human Rights Commission for just one purpose: to minimize or escape culpability for their crimes. Once the evidence against them proves insurmountable, they bring to us cases of torture. Until the Constitutional Court recently pronounced itself on sections of the Prevention and Prohibition of Torture Act, accused persons almost always invoked torture as a defense. By the way, they continue to do that. I have seen several of them walk scot-free on this ground. The Uganda Human Rights Commission cannot continue to shield violent criminals from consequences of their crimes. I will not, Mr. Chairman, I will continue to resist turning the Commission into a center for sanitization of criminals. Forged medical reports. There are so many torture cases we receive backed up with clearly forged medical reports. Mr. Chairman, we have a duty to do justice to both parties, to the complainants, but also to the respondent, who is always the Attorney General. We have a duty to be impartial to each of them. We cannot continue to entertain cases which are based on forgeries. Otherwise, that would be institutional bias against the state. There are so many examples. There are so many reasons we sometimes close cases without going into a full hearing. There are some which are brought before the wrong forum, like employment matters. We have an industrial court. Some are land disputes. Mr. Chairman, we cannot hear all these cases. Remember too, honorable members, the chairperson of the Uganda Human Rights Commission, under the Constitution, must be a judge of the High Court or a person qualified to be a judge of the High Court. The only qualification for members of the Commission is that they must be people of integrity and high moral standing, with due respect, Mr. Chairman. The presumption of the law is that this chairperson has an understanding of the criteria for admissibility of cases. How can this small issue be amplified into a crisis? Are we really serious? This chairperson is qualified to be a judge of the High Court. This chairperson is an advocate of the Supreme Court of Uganda for more than 30 years standing. How can she fail to determine parameters of admissibility of cases? How can the chairperson, in exercise of her authority under the law, sitting as a court or administratively, where she determines that these cases are not worth a hearing, how can that be a crisis, Mr. Chairman? On foreign travel,
excuse me, honorable members, I see two subheadings, foreign travel and motor vehicles. Should we really avail this time? Okay.
I'm over 60 years old today and flying